afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labourr, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Today is a pre-recorded episode. I have my mom's birthday this weekend, so I'm not going to be around on Friday. But if you have questions, please feel free to reach out to us afterwards. So my point in mentioning that it's a pre-recorded episode is that no live questions today. Let us know if you have any questions later on. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon so you don't miss an episode. Today, my law partner, Young-Ji is with me, and we are going to talk about the concept of turning turds into treasures. This was a topic that was requested on the listserv. Specifically, I think the person wanted to know how to turn a turd case into a retirement case. I'm not sure that we'll be able to give you that answer here, but hopefully you'll be able to use some of the things that we talk about today and find that retirement case. We came up with a phrase recently when we were celebrating a win in a case that we really did not have reason to believe had much merit. And it was one lawyer's turd is another lawyer's treasure. And that's true. If you work it, you can polish up a turd and see where it takes you. I'm not encouraging you to make a practice out of turd cases, right? We want to very much stay true to Edge's teachings on the case selection criteria. But we will talk to you a little bit today about how you can maximize the outcome of the case that you have in hand. As always, we'll put our contact information in the description below, so you can contact us directly with any questions about this topic or anything Edge. So let's get started. By way of a little bit of introduction into the turd case topip.
How many times have we said turd so far?
Turd. Say turd again.
It's a drinking game.
So if any of you maybe will remember, and Young-Ji definitely will, my superstar case was a turd case. And the reason I came to Edge was because I found after mediation that the case I thought was going to be like my breakout moment, excellent damages and everything else was actually a pile of you know what. So, I mean, it was a huge thing.
I don't recall that. I thought we knew from the beginning it was a bad case.
No, because Elle and I had poured a ton of money into this guy. They'd given him like years of time lost. They'd paid hundreds of thousands of dollars in, medical. They approved everything. And so we were like, well, we have a solid ass case because that's, Elle and I is at least workers' comp in Washington is very, very, very strict. So if Elle and I is accepting all of these conditions and paying out for all this medical treatment and all of his time loss and wages and everything else, how could anybody not?
We're so naive.
And yeah. So we ended up with an illegal immigrant who used a broken ladder on the job site. He knew was broken, fell, and had honestly, the smallest injury you can imagine.
Didn't break anything.
No fractures. No
not a scratch, not a stitch.
No, broken bones, nothing. And they had spy video footage of him doing every single thing he said he could not do. So, now I just want to remind people, though, the verdict I got, it was a 6-figure verdict. It was not a 7-figure verdict. And they found that our client was 60% responsible. So it's not like, I don't know.
We're in a comparative state, so it just reduces the verdict. It doesn't mean no.
Right. It doesn't mean no, but it's also like you can turn a case that it was no offer. I think they offered us $10,000. So we had to go to trial on it. So you can make a case better. But can you turn it into your retirement case? I don't know. We have yet to do it, but we definitely have proven that you can take a case that everybody would have turned down and turn it into something. Right? Something. Even if your client ends up with the majority of the responsibility, unless you're in Maryland, then, you don't want that. That's a pure
Massachusetts.
Yeah. So what do you think, Young-Ji? What are some things that, we've kind of learned over the years about turds and taking them and that sort of thing? I mean, I have a list here. We can go on my list or we can just kind of go, whatever you think.
I think to kind of discuss that Labourr case, it's kind of been our claim to fame in Turd to treasure status. I mean, literally so many lawyers know about that case. And we actually just got an email about it last week because somebody had a Labourr case and they said, oh, I remember your Labourr case. I had XYZ issue. Any sort of construction premises case, it's always going to be hard with liability, but we had so many other issues on top of it. And in every case, whether you feel like you have a really strong liability case, a really strong damages case, there's going to be a bump in the road. This case had a lot more bumps in the road. What we learned from it, and this is when we, metamorph into edge attorneys, is that you have to keep going until it's over. Even when this trial was over, we were like, oh my God, they're going to appeal the verdict, because the defense attorney, literally, she was from Portland. They had flown her in for this case. She literally hung up the phone when the jury read the verdict. Like, that's how angry she was. And she kept threatening to appeal it. She told Jenna she needed a mentor. I mean, all these awful things. And we were just so scared. Like, this is not the end of it. And, they have the money. It's a huge company, big law firm, to appeal it. So there's always going to be bumps in the road. I remember sitting at mediation, and, everyone has that case where you go to mediation, you're like, oh my God, I'm just going to settle it. Like, I can't wait till this is over. And you have that beggar's cup. Nope, didn't settle. No way it was going to settle. Then when the realization comes, like, oh my God, I have to actually try this case. Like, that is when the fear sets in. And you can't show your client your fear, because then they're like, oh, we're really down the river. So, I mean, that's when Jenna found Dawn and, really got into Edge and went to all the classes and we got a continuance, and she was able to implement and find the system failure. But it's never giving up. I mean, the tenaciousness that we have, we are just little, I'm not going to say pit bulls. We're little chihuahuas. We are little chihuahuas, and we don't give up. I mean, we've had days where we want to quit the law and we're crying and we're yelling and so upset. But in the end, all these cases that have issues, they resolve successfully. It's not retirement, because of hard work. And that's what Dawn always says. At the end of the day, you don't have to be a genius. You don't have to be a huge firm. You don't have to have, magic tools. You just have to work hard and never give up, because I see lawyers, young and old, just face a bump in the road, and they literally just put their head down and just get so distraught, and they'll withdraw from cases. They'll find co-counsel and say, please save me. They will settle it for nothing. I mean, these are common things that happen. And I mean, that's fine if people don't feel they cannot pursue it, and maybe for financial reasons, they can't litigate it or they can't try it. But you have to just keep going, because that's the thing. You have to keep going. You're doing this for your client. You're doing it for the greater legal community. You're doing it for the plaintiff's bar. If we just rolled over, took that $10,000 at mediation, they would have been real happy. Our client would certainly not have been, but you can always talk yourself into settling a case. You can always say, even during trial, they came up to us and offered us a lot more, 7 times that. And we were really inclined to take it. I mean, the fear is always back here lurking, and all the what ifs and all the risks and what's going to happen. But you just have to keep pushing along. And I mean, in the end, the system failure won, and the jury was on our side.
Always, to that point, remember what evidence you have. Always go back and look at what evidence you have. Now, if you're walking into something and you don't have any, evidence, and maybe you haven't done the right discovery or whatever, that might be a different discussion you have to have. But presumably you've got something that you believe that you've focus grouped and will get you over that burden of proof, that standard, right? So look back at what you have. Don't focus on what you don't have, especially if you can't get it, right? At least in Washington, by the point of mediation, you're most likely not able to get any additional discovery done. Our mediation deadlines, our ADR deadlines are after discovery closes. So you may be afraid, oh, I don't have this, I don't have that, I can't prove this, I can't prove that. Go back to your evidence. What do you have? What can you prove? And try to use that. And then the thing about the EDGE system is it takes the focus away from the plaintiff and the boo-hoo, poor me, look what happened to me. Especially in our latter case, that guy, not much happened to him. And what ended up being the bigger...
He was not likable.
And he wasn't likable. And these are all things, sadly, we didn't realize this until very, very close to trial. All of this stuff kind of dawned on us really late. We've gotten better at this, mind you. Okay, I don't encourage you to do your cases this way, but we didn't know about going to the client's home. We didn't know about spending time. We didn't know these things. But the thing that upset the jury the most was the conduct of the defendant, right? This huge corporation that had the resources to make sure this didn't happen and didn't. And then, we got a tiny shred of luck that they had I say shred, and that's because they had shredded all of their documents, right? So they claimed they gone to the site, done safety meetings every day, blah, blah, blah. And they had all these records, but we shredded them once we got acquired, which it might be true. I don't know, but it made, it was something that bothered the jury. So look at what
focus
you
groups.
have. Yes, and focus groups, and don't focus on what you don't have. One thing I also want to share with everybody is the case selection criteria, which we talk about a lot on the podcast, is super important. So this episode is not to tell you to hang out a shingle that says we take turns.
Yeah.
I don't know that we would recommend, Young-Ji and I kind of staked our fame on that case. And so we got, a few turdy cases and we're able to turn them around, and still some of them come in the door. But it's something that you can certainly do well at and take them if you're good and you have the time, resources to do it. It wouldn't be just kind of making your living on them, because it is a lot of work. So go back to that case selection criteria, make sure you're following it, make sure you pick the right cases. But say you do the case selection criteria and you take the case. And
what are the 3 points, Professor?
This is my worst one. Dawn did this to me over our New Year's Eve one too. And I just did a case selection memo criteria on Amir Fai's case. So random victims.
Yeah.
So system failure. Why should the community care? Is that the same thing?
Thinking random victims. I always forget STDs is the same as random victims.
Random victims. I'm going to pull up my memo here and we're going to go
system
through
failure.
This is another thing that's important when you're referring attorney. You learn about all the memos you need to do in a case. So how could it
happen again?
Random victims. Why should the community care? And what happens that can happen again? Mm-hmm. And it's important that those are in your case if you're going to take them. And if for some reason you find out that they aren't, look at the evidence you have and see if you can make something out of it. Look for that system failure and see if it eclipses any of the other missing legs there.
I mean, we're really, really selective about our cases. We have probably like 15 cases in our law firm right now, and it's just the two of us. But we probably have in the past few years taken like 1 or 2 cases per year. Before that, we had a bigger caseload. We were not as selective, but we always go to the case selection criteria. People will accept cases because it's big damages. Wrongful death. You think, wrongful death, there has to be big damages. Not necessarily. You have to look at all different factors. You can't just think, this happened, I'm gonna take this case. Always look to the case selection criteria, because that's what it comes down to in the end if you have a real edge case, and that's what is really going to have a jury want to give you that verdict or judgment and scare defendants to resolve it.
Another point is do your work early and do a lot of work. Now, your comment on the wrongful death reminds me of a case we had recently where we worked up we provisionally represented the client with a potential medical malpractice related wrongful death claim. And we spent money on an expert. We did a ton of investigation, a ton of research. We even talked to Papa Don about it.
Focus grouped it,
did the work. Ultimately, it wasn't a case that we believed we could pursue. But you do the work to find out if it possibly could be. And that's a good example of, making sure that your firm has the resources and the know-how to, maybe you lose a few $1,000s because you're going to really investigate that case. But Young-Ji, what did the client say to you after?
Oh, she was over the moon. Her mother had died. Her mother had died in a potential med mal case where she died from a routine pacemaker insertion procedure. And she was young, in her mid-20s, and she was so thankful to us for believing in her and her family. And, for maybe months, we've investigated for months. We retained a standard of care expert out of UCSF. We had another expert out of Chicago.
The autopsy.
Yes. We paid for the autopsy. All these things, you pour 5-10K into it, you're not going to recoup it, but you better to do that now than be 6 figures in deep, because that's what happens with med mal. So that was a case where we had the case selection criteria, absolutely. But then when you dig deeper and get to your burden of proof and what you need to prove in a med mal case, and then, having the experts, we had those qualifications, but then we got to the next step of focus grouping it and having another expert look at it, and it was a no-go. So these things are important to do the early investigation after you get past the case selection criteria, because you could be in 6 months litigation into a case and then realize it, and then you're going to be spending even more money to try to get out of it. So we've learned that mistake. You do it early on, even though you're going to spend money and might not recoup it. It's better than being a month from trial and being like, oh my God, I did not know this, and I just put 60, 70, 80K of costs into this case. So you live and you learn, but pay it up front rather than pretending it's going to somehow fix itself later, because most of these issues are black and white. You can't just try to find an expert and save yourself.
On the flip side of that, right, doing the work early and working hard, and you get a good outcome because you got a happy client who knows that you did that work for her. We had another medical malpractice case where the client came to us after the statute had already run. And so you may find yourself in a situation where you're making that decision. You don't have the time to do the investigation, right? And I hear people who are watching going, well, sometimes you just don't have time. I hear you. And here's, an example of when we've kind of worked through that. We believed at first blush that there was the case, all of the elements were met. We even through discovery found even better things, like good things about it. In Washington, there's a way you can pull the statute, by the way, for people who are wondering why we were able to take it after the statute. And so we use the discovery doctrine, which is when the person who was injured understood that they had an injury and connected it back to what had happened. So we were able to file. And then we went into discovery. And again, because it's med mal, we had to do a lot of work, and it cost a lot. Another tip along this, and I'm going to share this story with you, is to talk to as many experts as you can and get as much information as you can. One thing we really like to do is talk to defense experts, not only because they're going to give you the defense's best side and best information, which is always incredibly invaluable, but also because it conflicts them out. I will especially in your smaller car crash cases, when defense is going to hire a certain biomechanical engineer, I will go down the list and hire all of them. It may cost me $5,000-$6,000. I don't care. Even if it's a $30,000 small case, most of those are retainers. You'll get them back anyways, but get them off the table. Do the creative thing of finding out the resources and finding out the opinions, and then also, taking those tools out of the hands of the defense.
Yeah. Then the best part, they hate it. And the best part is at trial, you can say, how many times has the defense firm retained you? And they'll say, oh, dozens, hundreds. And then it's like, okay.
Exactly. And so in this med mal case, that's what I did. I went directly to a person who had testified against us before, mostly because we were still in this investigative stage, but we had to have filed already. And so I worked with her, and it was hard. She knew the defendant doctor, so she had an emotional conflict, but she was like, I think what he did was wrong. So we had enough evidence to proceed. Well, at a certain point, as I'm going through this, and I'm like finding out from everybody, everything possible. I'm talking to every expert I possibly can, doing all of the research, getting all the information. I find that the injury we believed was there potentially wasn't. If there was good evidence, had the defense done a lot of work, there actually maybe was not the injury we thought there was. And the point of that is we came to a crossroads of like, all right, what do we do with this information? Now, my second point on my list today is never lie. Never lie, never make something up, never withhold information that you are supposed to disclose. But if you don't have to disclose it, because it's never been asked of you, you've never retained the expert, you're simply doing your due diligence, you don't have to disclose it. So that piece of information, I kept it to myself. I told Young-Ji. But then, as I mentioned earlier, we looked at the evidence we did have. Mm-hmm. What evidence did we have? I had a very, very well-known and well-respected defense-oriented surgeon who was willing to stake her name and reputation on the damages were there. Mm-hmm. We had another forensic radiologist willing to say the damages were there. And they weren't just saying it because we told them to say it. They were saying it because they saw it on imaging and other things. So, yeah, I had a couple of experts I knew were out there that potentially could have tainted us if defense decided to use them or created problems for us. Number one, they were off the table for defense to use because I snuffed them out and talked to them about their opinions. And number two, I forget what number two is, but anyways, that's the most important. And number two, I did not have, I had that piece of information, but there wasn't the need for me to do anything with it to take my own case. But again, it's all information. It's good for you to know, right? And that definitely tarnished the case, but we were able to turn it into a really, really good resolution because we're aware. We did the work. We did the research. We contacted the people. We didn't just sit back and watch the case turn into nothing. And once I had that piece of information, I was like, okay, what am I going to do about it, right?
And
then you go on and...
An important point with that case where we got a lot of leverage was using another EDGE method. A big part of EDGE that you don't necessarily read in or learn about in the colleges is that you win cases with motions. You win cases by winning motions, arguing motions, making a record. And in that case, we pursued a corporate negligence theory, which a lot of attorneys don't do. And they hated that. The defense hated it. They filed motions for partial summary judgment. We argued it very strongly. And then the judge did grant the defendant's motion, but then Jenna kept woodpecking and she filed a motion for reconsideration. And she said, Judge, you got it wrong. And the judge was on the fence. She's very well read, very smart, but she was just really hung up on one issue. Jenna filed a motion for reconsideration and the judge ruled in her favor. And then that gave us leverage. That gave us value. Because that opened up a whole can of worms for this hospital that they did not want to deal with. It opened up a 30B6 deposition. And then when we got to mediation, I mean, they paid for the corporate negligence claim. They kept saying, oh, we're not paying for that. We're not paying for that. It's irrelevant, redundant. But that was what a huge part of the case was in the end. And you just got to keep woodpecking at those issues. I mean, now we always say, oh, we're going to file a motion for reconsideration, just like we did then, and we're going to win it. You can win leverage that way. I mean, right now we're arguing a motion for continuance that defense has filed 3 times. The judge keeps denying it. The judge keeps denying it, but defense keeps filing it. We keep winning, but I mean, you're still winning ties with that. That kind of stuff drives defense crazy because they think they're going to win. Oh, why aren't we going to win? When they start losing leverage, I mean, they're freaking out. 2 weeks from trial and they're trying to file their 10th motion for continuance, and this judge is probably going to deny it again or grant a very short one. I mean, that's winning leverage with them. You just got to keep woodpecking.
That's an excellent point too. Make sure you use the tools that you have in your legal pocket as well. Know the law, know your jury instructions early on. What do you have to prove? I mean, going back to what we've been discussing about focusing on what evidence you do have rather than what you might wish you had, or, look at that. Is it enough? Get into a focus group. is it enough? File motions, be a very well-rounded fighter. Talk about MMA. You have people who have very specialties in certain areas, but if you're a well-rounded fighter, you can, strike, you can take people to the ground. You've really got to be a well-rounded fighter. I mean, we see a lot, I think, with some of the larger firms or the more well-known firms who get cases that are kind of wrapped up in a bow, a little bit simpler, that sort of thing. And those are the types of people we tend to see fall apart when there is a challenge in a case, because they don't see those all the time. So be the person who's scrappy, be the person who does the work. And when you have a case that isn't perfect, isn't wrapped up in a bow, you'll be better equipped to handle it and turn it into something.
Mm-hmm. Be a woodpecker.
Yes. Another thing that Papa Don has always told us, and we keep it as our North Star: mean what you say and say what you mean. Every decision we make revolves around that. Okay, because reputation is everything. That's the point of that phrase. Reputation is everything. If you say, we are not going to mediate unless you pay for mediation, and then you find yourself in a desperate situation where you really need to get into mediation.
Yeah. Turd case.
Yes. Figure out a different way of getting it done. Mean what you say and say what you mean. It also makes you a little bit more careful about the claims you make. Make sure that you can back them up. Make sure if that person, defense counsel doesn't pay for mediation, you're fine going to trial. I'm trying to think of other little situations where we've been very tempted to cave.
So many.
Yeah.
Well, our other superstar case was a trucking case against an international freight company, and it was in federal court. So in federal court, as many of you know, ADR mediation is not required. So it's a great place. Whereas in most, in King County here in Seattle, mediation is required. Because of that, I mean, people don't take it seriously. Defense isn't scared by it because you're forced to go. So you have no leverage. You can't send your edge conditions letter because it's complete bunk because you have to go. And judges will get pissed at you if you don't go. And I mean, they're trying to get you to mediation, so it goes off their docket. So when we're in counties or in federal court where it's not required, it's awesome. You can be sitting on the worst case, and I am sitting on a really bad case right now, but you still have to put your foot down. You still have to bluff it and fake it till you make it and say those conditions. I'm not going until you pay for mediation. I'm not going until X happens. Why? Because you have not made one offer in this case, because it's a complete waste of time and I'm getting ready for trial. I don't have time for this. Then we also say, we don't need to go to mediation. It's not required. If you want to make an offer, let me know. I'll tell my client.
Yep. They
freak out. They don't know what to say because they'll say, send your demand. Which mediators do you like? And when you respond with that, they don't know what to do with themselves. Mm-hmm. They freak out. They disappear for weeks at a time. They're in their boxes being like, what do we do? Mm-hmm. And for our trucking case, we were very firm about that. At first, they were screaming up and down saying, what? This is ridiculous. Finally, they caved. They paid for everything. They listened to all the conditions. And then even after mediation, when it didn't settle because they didn't reach our cut number, they were begging to go to another mediation through a settlement conference judge. And we said no, but this was a bench trial. And again, they begged the judge and said, please, judge, can you please assign us to a settlement conference judge? And the judge's clerk reached out to us and said, oh, are you agreeable to this? And we said, we are ready to go to trial, but if the court wants us to go, we will go. And the clerk said, oh, okay, we're not going to force anybody to go. Case settled 2 weeks before trial for above our cut number. And yeah, it's about standing your ground. It's about showing them you're not scared to go to trial. We're all scared to go to trial, but at the end, you have to think, I'm going to try this case because I looked at my case selection criteria. I have the facts. I have the evidence to back it up. I'm scared I'm going to lose and be in the red, but you have to put your foot down because you can't turn and if you tell somebody you're not going to go to mediation, you can't turn around a week later when things are going bad and say, okay, I'll come and meet you there. You're losing leverage. You're losing your reputation.
Yep. Yeah. Another thing about reputation, we had a small car crash case out in Jefferson County, and we had set a cut number on that one. And a mediation, they were like $50,000 away from it. Mind you, that's a lot in a small case. So it was a small case. And we had to walk away. We had to, because we had set that number. We had said, this is the lowest we'll go. We had to walk away from mediation. That was tough. Luckily, we had a couple of continuances on the trial, but at no point, and it would have been hard. Like, I am not entirely convinced that we could have gotten our cut number at trial. There were a lot of variables that were against us. The client started to cave. The client's condition I started to cave. Yeah. It was like, we were staring down the barrel. The judge, we had done motions in limine. He made terrible rulings. It was a county that only had one or two judges.
Yeah, one.
The county had one judge. He had to recuse himself because the defendant was a lawyer. So then we were bummed. We had a guest judge, but still, that person, they don't have car crash cases out in these counties. Those cases go to the bigger counties. So, but I had to have a conference with Papa Don about this, because I was like, my client has instructed me to settle this. She wants out. She is done. She is like, I don't want to do this anymore. I don't want to testify. She'd been in a prior case, civil case, that didn't go well with another lawyer, and just didn't want to get on the stand again. Her husband was a terrible witness. It wasn't going to go well. And Papa Don said, your reputation is everything. Mm-hmm. The second you take a penny less than you said you would take, they won't trust you. And then you lose everything. So we talked about a few really good ways of trying to figure it out. What ultimately ended up happening, strangely enough, my client swears that she manifested this. So I don't know if it was her or if it was me, but we ended up settling for higher than that cut number, because ultimately a new adjuster was assigned to the case. We always knew it was the adjuster who was problematic. And we were able to get it done. But there was so many times when we were like, let's just take a little bit less. Let's meet them in the middle. Let's call it a day, but do not do it. Manage your expectations. Don't be unreasonable, but don't cave. Say what you mean what you say. And when we were referring attorneys on that case that Young-Ji was just talking to you about with Papa Don and Mindy, they would say that all the time. And we'd be like, well, what if we do this? They're like, did you say that? Did you mean what you said before? If not, if you didn't mean it, fine, then do something else. But if you did mean it, then you have to stick to it. Otherwise, everything you say is a lie, and that's never going to advance your case. Overarching theme, realistically, is, like Young-Ji mentioned, fake it till you make it. And it's not about lying or making up evidence or withholding evidence. It's about knowing the strength of the evidence you have. And how do you do that? Focus groups. Mm-hmm. Put what you have in front of a focus group. See if it resonates with them. See if it goes anywhere. If it does, those people are your jury. So you've got enough to keep heading on. Keep faking it till you make it. Keep bluffing, until you get there. So, another EDGE principle that we utilize extensively is focus groups. So we had Gus on to talk about undergraduate focus group class. That was super inspiring. I signed up for graduate focus groups because of that. So I'll be doing that later this summer. And that's just a wonderful way to know where your turd really stands. Is it something that can be polishable? Yeah. Or not? And, calling it a turd is actually important, because you can't turn a turd into anything that it's not. You can polish it. Maybe you can turn it into some like petrified wood looking thing, but it's always going to be compromised a little bit. At its core, it's stinky and rotten. So the best you can do really is to do the best you can with it, and keep in mind what? Frame it. Exactly.
Not frame the turd. Frame your case right.
Hang it on your wall. Yeah. But yeah, and that's what EDGE can help you do. Another thing we talked about last week with Hoey was EDGE does not teach you to manipulate. EDGE does not teach you to I don't know, mind voodoo anybody.
Yeah.
It teaches you to know the law and follow the law. And that's crucial because so many, and Young-Ji and I see this all the time, where lawyers will take a rumor about a holding in a case or something you're supposed to do during trial and run with it and take it as fact and gospel and not really look into it. But if you do the work and you look into it, that's not really what the law says. So what EDGE teaches you to do is find out what that law really says and
read the case.
Yeah, look at the case. Look at the rule. Look at in Washington, it's RCW, Revised Code of Washington, whatever you've got in your respective state. Look at what it says. Look at the jury instruction. Oh, you have to prove XYZ. Says John Smith. Okay, John Smith, do you know that because you read the jury instruction, or are you saying that because that's the rumor you heard down the grapevine?
Mm-hmm. Yeah, is that what you read on the listserv?
Yeah, exactly.
I mean, I'm so guilty of that, and Jenna's been teaching me the ways.
Read the case.
Yes. She always yells at me. I am not one. I'm not big into briefing. I'm not a briefing nerd and wanting to get into writing, or I do not strive to be an appellate attorney. Jenna, on the other hand, was on law review, and she's a total bookworm, and she loves to read and get into things. And we've just found that a lot of times when you're a young attorney, you just think like, oh my God, I don't know what to do with this issue, this motion to exclude, or this or that or the other. And you just deep dive into your listservs and find, sample motions and think that's going to, save you. A lot of times it didn't save us. And what we found, like in the corporate negligence claim we were just talking about, if you do the research yourself, which God, we hate doing research. I mean, and lawyers will ask us, oh, have your associate do it. We are the associates. There's nobody else. It's not that we don't want to hire somebody. It's that we want to do the work ourselves and trust ourselves to do it, because that's how you're going to really understand it. It's, you can't have somebody else brief it. Like, my brain just doesn't work that way. I'd rather do it myself. Maybe we're just control freaks in that way, but Jenna, she read 30, 40 cases about corporate negligence in Washington, and she can really teach you about it. And she teaches me about it. And we just had another MSJ and another corporate negligence claim last week. And, the EDGE method of role playing and arguing for MSJ and all those, it's really helpful to learn from each other, but also learn it for yourself. Don't just read the TLDR. Don't just go on your Westlaw. We don't even have Westlaw. Don't go on your Westlaw and read the key or whatever it is. Read the whole case. You have to interpret it, not what some other lawyer did and has been doing. You have to read it. You have to educate the judge. A lot of times, especially here in King County, we have so many new judges, and 80% of them are former prosecutors who know nothing about civil rules and nothing about civil procedure, and we have to educate them. That is our job. You are the lawyer. It's not the expert. You can have experts supporting your cases, but you are the attorney. You need to know what the cases are. It's not fun. I hate it. I mean, it's like if I have a day where I have to do research and briefing, I'm like, God, kill me, but you have to really get in there and understand it so that you can advocate and teach the judge and have them turn. Because, I mean, we have a motion for summary judgment order pending right now. The judge is very well read in plaintiff in civil procedure, civil law, even though he's a former prosecutor. He's probably the best civil judge we have right now in the court. I think he's having a hard time. I think he is having a hard time with the corporate negligence claim. And I think he's sitting in his quarters, phoning a friend, doing research, because he wants to get it right. Mm-hmm. And that's what judges should be doing. They should be thinking about those things. And that's what we want. But I have to know it too. I can't just say, hey, read this case, Your Honor. So that's really big. I mean, that's what EDGE teaches you. That's why we have the Black Letter Law course, which I haven't taken yet, but this is why it's so important that you know the law in your state. Don't assume it's the same as what you read somewhere on a listserv. Don't assume that case has this holding when it's not that at all. I mean, defense just makes up stuff all the time. So you have to know it for yourself and really dig in. That's been our motto recently, as of late in the past year, because we've been really good about arguing our motions and woodpecking. Jenna just said, did you read the case? Yeah. Did you read this? I'm like, well, no, I didn't. So I'm going to do that now.
That's the thing. And for me, it stems from just not trusting anybody, because someday, if anybody feels like it, they can listen to my sob story about my entire legal career and how it culminated with the wonderful relationship I have.
That's going to have to be a 3-part podcast.
Yeah, but I don't trust anything anybody tells me. I don't trust a judge if they tell me this is a holding. I don't trust another lawyer if they tell me this is the way you're supposed to do it. I need to see it in writing, and that's where that kind of comes from, that skepticism. And that's how we have developed, polished these turds. Number one, going to that black letter law, knowing it better than the judge, knowing it better than the defense counsel. I just had a 26I yesterday on a case with corporate negligence involved, and the defense counsel had no idea what I was talking about. And I said, you know what? Today is not the day for us to have this discussion. Inevitably, when you guys file your motion for summary judgment, we will brief it out then. But for now, let's just, get our discovery discussion going. But you have to know the law better. And again, that's another course, black letter law course with Edge, because that's what it's about. It's not about voodoo. It's not about magic. It's not about manipulation. It's about being smarter. And, and I guess to the extent that you're manipulating anybody, you're stopping the manipulation that the defense has been doing all these years. And plaintiffs' lawyers who are too lazy to really go to the root of it have been just accepting it and, carrying this along and really harming the rest of us, It's pretty bad. But again, going back to the turds to treasures, you want to know the law better than anybody else. Also, know the medicine better than anybody else. That's another way you can, don't take your expert's word for it. That person, sometimes you can educate your expert because the medicine better or whatever it may be. We always talk about the fact that as plaintiffs' lawyers, we have to be everything. We have to be doctors. We have to be lawyers. We have to be judges. We have to be psychiatrists. We have to be elevator techs. Remember when you were an elevator tech, Young-Ji, because you had to do that elevator case? All that are experts. What?
I know all about that. You know about dog bite cases and this and that, and standards of law, gross negligence. What does that mean? All these different things that you don't think you know about, you become an expert in.
Yeah.
And I mean, just a case in point, this case that Jenna talked about in our podcast, the trial we just had in April, it's over. It's done. The client doesn't want to appeal it. That's another issue. Make sure your client is ride or die, ready with you till the end, not just there to move on with their life, because that can also harm your reputation when you have set your case or your verdict up for an appeal and your client's like, no, thanks. I mean, now defense lawyers think, oh, they're not going to appeal their cases. So those are things to consider too, but it's over. One defendant paid out, the second one hasn't. We're having this whole argument about how a case is supposed to be resolved. I mean, literally, we're arguing civil procedure. The judge is getting involved. I mean, it's just going on and on.
Sanctions are flying.
Yeah, the case is over. At the end of the day,
referrals. I mean, the judge has been very upset with defense counsel for holding this up. I mean, yeah.
Again, this is about reputation. Yeah, we can just say, okay, I'll sign the dismissal, send the check, but no. And this is the problem. Other plaintiff lawyers have done it the way defense firms have told them to do it, because why do they care? They just got a big check and they're going to run off. It's important to make sure you tread the line, make sure the law is right, make sure you're doing the right thing, because then defense lawyers will cite to it and say, oh, so-and-so firm did it this way. What's wrong with you? And you can't just say, okay, forget it. Who cares in the end? Because it's all reputation, and we have cases against this firm. We have another trial with this firm in a few weeks. We need to build our reputation with them. We're not going to just roll over when you tell me to do this, that. I'm not going to jump when you tell me to jump. We are going to stick to what we think is right and what is correct. Don't just think, oh, I'm just going to take my check and run, and that's what my client wants me to do. Clients don't know. That's why they have lawyers. This is why it's important that these things are done so that they learn their lesson. In Washington, we don't have punies. We can't punish them, but defendants and defense lawyers can learn lessons. They can't just bully us around. And trust me, we get bullied a lot more for being young and female and all those things that people think. And we can't just let them do whatever they want, because this is how you build your reputation. This is how everything comes out in the end. This is how they resolve claims. When they look up your firm, they look up your name and they think, oh, we've dealt with them before. Ooh.
Mm-hmm. Yep. Your reputation is part of the polishing of that turd, because you can wrap it in what you've done previously, and your reputation precedes you. So, I wouldn't say that people really know who Young-Ji and I are necessarily. It's not like defense firms are like, oh, but we're working there. We're working towards it. And we're, step by step, by sticking to our guns and, meaning what we say and saying what we mean, we are getting to that. And any defense firm who doesn't know who we are, they will learn, and they do learn. And that's super, super important. Let's see. One of the things I wanted to talk to people about is, we talked about early on doing your investigation early and doing a really thorough investigation. Do not forget about your lay witnesses. Mm-hmm. They are crucial in every case. You have to have your experts. But I always say that experts are for your judge. Experts are for meeting the burden of proof so that you can continue on the case and not get kicked out on summary judgment. It's that's what those things are for. But for your jury, lay witnesses are crucial. And also, lay witnesses' memories fade like that.
Oh my God.
A month goes by and they're like, wait, who was my best friend that I used to eat lunch with at work every single day for 3 years? It's amazing.
Yep.
Get that stuff down in writing. Get it done early. You'd be surprised. Lay witness stuff can polish your turd. Like it really can, because it's such pure testimony. Mm-hmm. In the latter case, the only lay witness we had was our client's wife, and she was, I felt, probably one of the most dishonest people I had ever, in client wise, ever come across. She would say anything to help her husband, which, hey, wouldn't we all, right? But it was scary for us because that's the person we were going to put on the stand. Well, guess what? She was like the jury's number 2 favorite witness. It was this one doctor who I also had a bad relationship with, and this lady. So, it's the purity of somebody who doesn't necessarily have skin in the game. Now, not every jury is going to react to every lay witness the same way. We've had cases where they say, oh, well, the lay witnesses, it's their friend, it's their family member. Of course, they're going to say this or that. But get those declarations early on, get that information early on, because it's only going to help, especially if you find out later on that your case is not so great and you want to settle it. It'll help. It will help.
Because trials are, as Dawn says, trials are won by emotion. And lay witnesses, they're not experts, they're not technical, they just tell it how it is. I mean, that's where the jurors can relate. So, yeah, you get as many as you want. We haven't been able to edge it up as much, and people say, oh, you need 10 or a dozen short lay witnesses. We haven't been able to do that, especially. I know it's really important for TBI cases, but that is so hard with TBI cases because as everyone knows, TBI clients are not social and they're isolated. I mean, they don't even go to the dry cleaners or the grocery store that you could have somebody testify to what they're like. I mean, that's the hardest part of some of these cases. So trying to, and a lot of times clients, it'll be like a month before trial and they'll be like, oh, what about so-and-so? What about so-and-so? I'm like, why didn't you tell me this a year ago? I know, it's just like all of a sudden. So you really, from the intake to ongoing meetings to witness prep, you have to keep asking your client, who else could tell me about that? Who else could testify about that? Tell me more. Give me their number. I'm going to track them down. Use your skip trace software. I mean, I just had a continuance in a premises case, and all of a sudden my client's like, oh, what about so-and-so, my coworker? I'm like, you didn't want to tell me for the past 2 years? I mean, it's just clients.
She doesn't have a brain injury, folks. She does not have a brain injury.
She does not. Well, she's 84, but still.
Yeah, well.
It's just clients just don't think the way we do. We are thinking of evidence and burden of proof. They just think like, oh, is that really important? Even lay witnesses are like, wait, why is my testimony so important? Can't you just put it on a piece of paper? I mean, I've had people say that to me, and I say, your words are evidence. I mean, sometimes jurors don't even understand that nowadays.
Sometimes doctors don't understand that. They're like, you have my reports. Why do you need me?
Right. It's just like, oh my God. And, this is not a document trial where we're going to give you hundreds of pages of documents for you to review. That's also not an edge way, but we need witnesses. They don't need to be long. They don't need to be elaborate. They just need to have substantive, good, anecdotal, specific information to relate to the jury. And the more, the better, but it's really about quality versus quantity.
Yep. Another thing, so next week we have Stacey Cutting coming in to talk about mediation, undergraduate mediation college, and that ties in really nicely with what we're talking about today, because there may come a point where you feel like, if I had to try it, I could, and I would, because I have, enough, but it's probably a better case to settle. Mm-hmm. And, that's a great college to go to learn how best to do that, because a ton of work goes into what we do as edge lawyers in mediation and how we demonstrate, what we have and what might potentially happen at trial, and to leverage that with opposing counsel and the money holders, whoever's going to be there, insurance adjuster, risk manager, whoever it may be. So that's something to consider as well. The work doesn't stop at mediation. Let's say you think you're going to settle. Well, it is what it is. You work really, really hard all the way through. I mean, if you take nothing else from this episode, I feel like all the episodes, you have to outwork the other side. There's just no shortcut. There's no easy way around it. You have to outwork everybody else. And in the end, you know what? Do you know who I remember that was a terrifying case?
So many. Which one?
The slip and fall in the bathroom by that paralegal at that law firm.
Oh, yeah.
Yeah. So we had a client who, and it didn't turn out well. So, you can polish a turd as much as possible. It may not always turn out well. But in this case, she slipped and fell in a bathroom and injured herself. But her real claim was PTSD, because she was locked in the bathroom from anywhere between 10 minutes and 30 minutes. The record varied. And we decided to proceed with the case. First, this woman comes in and tells us her story, and we're like, you're completely insane. That's no way, no how. Mm-hmm. That's not PTSD, no. But I looked at the medical records. She had a psychiatrist diagnosed her, connected it to what she went through. She had tons of medical records. And so we took it, and I figured, this is a workers' comp case. So I figured worst case, she is where she is today. The condition doesn't get accepted. Best case, it gets accepted. Okay. Either way, we've done a good job and, put our best case forward. This is, I guess, Young-Ji mentioned this when we were kind of talking today before we hopped on the podcast about sometimes when you should really run away from a case. And one of those is when you have some red flags with your clients. Mm-hmm. So you can polish a turd of a case as long as you've got a client who is honest and true and believes in what's happening and is not, a bad person. Yeah. We polished the crap out of this turd, and we did an awesome job. And the appeal didn't go our way. In workers' comp, it's called an appeal. But we worked so hard, and it was a wonderfully put together case, and it was the best we could have done, right? Well, red flags had been throughout the case with the client. She was emotionally unstable to begin with. There was a lot of issues in her life, and those are things when your client lies to you, when your client is giving you conflicting information, when their story changes, don't ignore those things. If you have a turd of a case and you have a client, and Young-Ji can share with you also other scenarios.
Yeah, I think I've learned, and I'll give two case scenarios, but I've learned that that's my deal breaker, because we do so much for our clients. We're filing all these motions they don't even know about. We're conducting all this discovery and these depots, all the work they don't know. If I'm doing this for them, I need to be able to trust them. 100%. I need to be up to bat for you. And I will do that. Even if your case has so many issues with it, So there's two cases where that happened, where one, we had a dog bite case, but it was actually not a bite. It was a dog attack case where a delivery guy had a dog chase him, lunge at him, and it didn't bite him, but it made him basically fall backwards and mess up his knee. So extensive damages because he had to have knee surgery. He was out of work for a while. We represented him on the underlying workers' comp as well. From the beginning, the client was very difficult, just kind of an angry, cranky guy. He would yell at my L&I paralegal, just be very rude, all those sorts of things. And then when we were working on his third-party case against the at-fault party, I'm prepping him for his deposition. We do the whole witness prep deal, whatnot. Following day after that, I do a gut check. He tells me, we've spent years with this guy because we were representing him on a workers' comp claim. All of a sudden he tells me, oh, I didn't tell you something. I didn't think it was important. Basically, he didn't tell me part of his criminal record because it had been expunged. So he didn't feel it was necessary. His criminal attorney told him if it's expunged, he doesn't need to tell me. He's telling me this right before a deposition where they're obviously going to ask him about a criminal record.
He'd already sworn under oath to written interrogatories too.
Yes.
On that topic.
So
criminal history.
That was absolutely a deal breaker for me because I felt betrayed and that I completely lost my trust in him. I really could not believe anything he said to me. We ended up withdrawing from the case because we felt that was the best action. I talked to him about it. I told him why. I'm like, I have nothing against you. This is just, for me, I feel our trust relationship has been broken. He filed a bar complaint. I had to respond, all these things. So that was when I learned, when something like that happens now, I get those tingles on my back and think like, oh, I'm getting those flashbacks. So that's a deal breaker. Whereas we had another case, discrimination, sexual harassment case where we talked to this client that was referred to me by a good friend of mine, and she had been harassed at work by her boss. And I say that lightly, and I don't mean to be rude, but when I was talking to her on the phone and Jenna was on the intake with us, the things she described that this boss did, it was like waiting for the shoe to drop. She would say things like, he would stretch and moan. He would say, oh, I'm so sore. Things that were not overtly sexual, which again, it's obviously not acceptable behavior for a boss. And it absolutely made her uncomfortable. It absolutely created a hostile work environment for her, and it was pervasive, all those things. But the case was, what turned for that case is the fact that the client was very credible. With employment cases, you usually have clients that have a bad past. We've had clients with drug history, we've had employment clients who've been in prison, jail, all those things. And it always comes down to the client and their credibility. She was great. She had no blemish on her work record. She had a quote normal education background, all those things. And she was always very credible, even though the harassment wasn't something that you read about in the news or would make front page news. And it actually was not like directed at her per se. And, he never touched her, groped her, said anything explicit. She was very disturbed by it. I mean, she was crying on the phone and they were real tears. So I always felt, like I'm not 100% in love with this case. And Jenna felt that way too. I'm like, but she is such a good, credible person. And what happened to her, she eventually was betrayed by the supervisor, the president of the company, actually, who was trying to help her and on her side. And they ended up terminating her and saying that she quit. Huge betrayal. I mean, just absolutely wrong behavior. And, they didn't investigate. They didn't do anything that a system failure would comprise of. So that was why we felt so strongly about that case. In that case, I was like, okay, maybe I would get 1 year's salary out of it. And maybe that's it, because I just didn't see much in damages. But it ended up being a very favorable settlement. And I think it really showed us that if you have a good client, you can really believe in them, you can make it work. You can make the system feel, we had an HR expert, which a lot of employment attorneys don't do. We set it up and we had a great 30B6 deposition, all those things so that we could at least show, hey, it might not be like the harassment cases you read about, but it wasn't Johnny Depp and Amber Heard or anything, explicit like that. But everything that was done to her was absolutely unacceptable behavior in the workplace. So, I mean, that's where you have to really have a good relationship with the client. And, recently I had a client and we're still in litigation where I started getting the tingles again. And I was like, oh, I don't know. I feel like he's being inconsistent. And mind you, he has a brain injury, so he has memory issues. But I started doing investigation on my own. And, we started requesting certain things from his former school and doing deep dive investigations into him just because I felt like something was up. But fortunately, that has been corroborated. So I don't feel I need to withdraw from that case. But you need to listen to your instincts and your gut. If something doesn't feel right, you can't just be trusting of people nowadays, and you need to really investigate.
Mm-hmm. Yeah. And, even as Edge, we're not supposed to put the focus on the plaintiff necessarily. You can't ignore that the plaintiff is a variable in your case. And so that's why I wanted to really have this conversation about your client when you're dealing with a turd case in particular, is who is your client? Who are you fighting for? And why are you fighting for that person? At the end of the day, we are doing this because we want to make the community safer. We want to deter future bad conduct. If you're in a state with punitives, you want to punish somebody for doing what they did. It's not all about compensating the plaintiff, but and Edge actually does a really wonderful job of teaching how to handle a situation where you don't have a good client, but you have to have a good case, right? In those situations, it's very, very difficult. I mean, okay, the latter case was one just anomaly, I suppose, where you have not a good client and a difficult case, but you have to really pay attention to that and pay attention to your relationship with that client and whether it's going to tank the case, whether the jury is going to feel about your client like you do.
Mm-hmm. Yeah.
And I mean, that's not saying like we have weird clients. We've had clients who are weird and they have strange personality quirks and you don't necessarily love them and want to snuggle them, but they're honest and they have enduring qualities, and Edge will teach you how to bring those out. And that's what the whole witness prep course is about.
As long as they're not lying. Like the latter guy, he was absolutely a guy who liked to embellish. I mean, in trial, he was standing in the back of the courtroom, like moaning in pain, like literally moaning in pain and like doing squats and stretches. I mean, you could just hear him in the whole courthouse. A lawyer actually came to observe and she said, you need to make your client quiet because it's really annoying and distracting. But that's what he wasn't lying. It was just, he was kind of an embellisher, but there's a difference between somebody who's emotional and will be a bit more vibrant with their emotions.
Or wear a bright red suit to court.
Yeah, that too. Or versus somebody who's outright lying and trying to keep the truth from you. And you can see that. And if you figure that out, or if you have an inkling about it, somebody's going to find out too. So
absolutely. All right. We are about to our hour. So I want to thank you so much, Young-Ji, for being here with me today. We always have such a good conversation.
So much fun.
I hope that those of you who watched the episode today, or if you share it with folks next week, will learn a little bit about how persistence pays off. Hard work will shine up that turd. Edge principles will help you do the work that needs to be done to make something out of a case that you have decided to take that might not be perfect. So thank you to all of you who joined us for this week's episode of Fridays with Keenan's Cutting Edge. If you liked today's episode, please click that thumbs up and click the alerts icon so that you don't miss an episode. Next week, we are going to return to our KTI faculty series, as I mentioned earlier, and we will have Stacy Cutting with us talking about the undergraduate mediation college. I stand by what I mentioned earlier as well. This is a great one to follow today's episode because when you realize you have a turd of a case, you may only be able to polish it enough to get a settlement. Depends on what your focus groups tell you. Stacy is an incredible trial lawyer. And when you talk about hard work, Stacy comes to mind. She works the hardest, and she's made herself partner at a firm that Mindy Bish started out of Los Angeles. So I look forward to learning from Stacy about the undergraduate mediation college with all of you. Have a wonderful weekend, and I will see you next time.